It's just 12:15 right now, so we're going to jump right in. And my name is Paul Hitchcock. I'm with Barth Calderon, and welcome to this episode of Wealth Protector TV. And this is a real hot one covering two really important issues: the new tax proposals from the administration in Washington that are on the table. Harry's going to talk about that. And then, of course, Prop 19 in California has a lot of people scrambling, trying to figure out what's going on. And I have two guests here, very fired up. I have Alexandre Alvarado from the American Apartment Owners Association, which you can attest to this. Alexandre is the largest association for landlords in the country. Am I right about that?
That's correct.
Great. Well, Alexandre is going to tell us, start out here in a minute, about what her organization is doing around Prop 19. And then we're going to move into Harry Barth, who is the founder and senior managing partner of Barth Calderon, which is an asset protection, estate planning, and business planning firm with a national footprint. And Harry is in high demand for his talks on all of those topics and is fast becoming an expert in Prop 19. And so we're going to get into those issues with Harry. He speaks across the country to many incredible groups. So very, very excited to have both on here with us today. I want to mention before we jump in, I'm going to share my screen here. We are not going to be able to get to every single question that's going to come up here. There is a lot going on with the issues you're going to hear about today. So as a way for us to give back to our audience, and we love doing this, is having a complimentary strategy session one-on-one with the team to look at your particular situation in regards to what we're talking about today. And so what you want to do is to sign up for this is text guard assets to 474747. And when you do that, you're going to be able to get on the calendar and schedule your one-to-one session with Harry and the team. So take a picture of that. I'll also put it in the chat, and we'll also get you some bells and whistles along with that. We have some great PDFs on this topic and some videos pertaining to it. We're also recording this video, so we'll get that out to everybody who registered for this event. So make sure you text this. And with that, we're going to jump into it. Stop sharing my screen here. Alexandra, tell us what's going on with AAOA.
Absolutely. So thank you for having me. First of all, Paul, this is great. For those of you who don't know me, I'm the Director of Marketing and Education at the American Apartment Owners Association. We do have the largest association for landlords in the country, and it's free to join. One of the things that we do is we try to stay sort of ahead of what's happening and educating our members as to what they can do to prepare for anything that might come their way. So for something like, a transition of a new president, this could mean a lot of changes in terms of taxes, especially. We actually just had a tax webinar moments before this one. And one of the things that our speaker said on that was, it's okay if things change. There is time to prepare. And so learning about things that might be proposed now is really the best strategy. Unfortunately, with California, the Proposition 19 that was passed gives very little time. So like it or not, you really have just a couple of months to prepare for some of the estate planning taxes that may be coming your way if you don't do something before the cutoff, which I believe is in February. So what we're trying to do as an organization is really let people know that these things are happening and help them with resources like you all, Barth Calderon LLP. I mean, really have been a great resource for our members. So I think another thing as well is just that we really just need professional guidance in this type of time because these changes are coming so quickly that, this isn't a time where you can mess up, for California landlords at least. You really need to have sort of some clarity and guidance to be able to figure out what your next move is. And I'm actually here to learn too, because I know what the problem is. I don't know what the solution is. I don't know enough to really tell our landlords, I'm not an estate planning attorney, but I really want to take this time. And that's why I've invited some of you on the call who are our members to join, because it is very important for you to learn this information too. So, that's really my spiel. That's all I wanted to say. I'm going to put in the link to join AAOA for free. Honestly, it's free to join and it keeps you informed. We not only invite you to events like, this one that we're on now, we have our own as well, where we have guests like Harry and Brad Barth who have come on and talked to our audience. We have other professionals that can help guide you on really a multitude of topics. So really, if you join for free, you'll stay in the know. I'll put the link in the chat for you to join in. And I'm really glad to be here because like I said, I'm here to learn as well.
Great. Thank you, Alexandra. Harry, it's all yours.
Okay, well, thank you, everybody. It's good to be here. Thanks for joining me today. I have a lot to talk to you about. I have a lot to talk to you about on specifics and a lot to talk to you about on qualitative issues as a result of kind of a perfect storm of a change in political climate and environment and a recently adopted proposition in California that has long-reaching and significant impact. And a lot of people, it's amazing, even when I speak to my peers, my fellow lawyers, that they just didn't understand what actually happened. So we'll start with an overall statement, a statement that I think is critical for all of us to understand. We understand this, but it's never articulated. The power to tax is the power to destroy. And we give governments the power to tax, and sometimes they use that power in which to destroy. Now, let's talk a little bit first about California and Proposition 19. So to understand a little bit about Proposition 19, we have to understand a little bit about Proposition 13 and the history of what's happened. So there were two components. One component that was interesting was that when people in the state of California reached the age of 55 years old, and maybe they wanted to go to a different place. They wanted to buy down, go to an over age 55 community. There was a procedure for that, but it was very, very limited. It basically said that, you could buy another house within the county or within an agreeing county for not a penny more than the house that you sold. And you could do that once in your lifetime, and you would be able to keep your assessed property tax base. So if you had $1 million house with a $400,000 tax base, and you lived in Orange County, California, and you wanted to buy another over age 55 community in Orange County, California, you'd be able to buy that for $1 million, but not more than $1 million, and keep your $400,000 tax base. But it was very restricted. We had to claim the exclusion, and if it was $1 million, $1, which could happen, or if the equity was not exactly the same on the note, the house and the property would be reassessed. And that reassessment would take property taxes from $4,000 plus to $10,000 plus. And a lot of people couldn't afford to do that. So a lot of people didn't move. They didn't get the opportunity. So Proposition 19, the forward-facing part of Proposition 19, which to me was highly deceitful, turns around and said, well, now under California law, if you're 55 years old and over, you can move anywhere in the state and you can buy another property, even if it's more expensive. I'll show you how that's calculated in a moment. And you'll be able to keep your assessed property tax base with you. So, and you could do that under the new Proposition 19 3 times. Not bad. So that basically means that if I had a house that's worth $1 million and had a $400,000 tax base in it, I could turn around and I could buy another house anywhere in the state for even more than $1 million and keep my $400,000 tax base. So if my house is currently worth $1 million, I buy a new house for $1,400,000, I would have my $400,000 tax base, and my $400,000, the difference between $1 million and $1.4 million, would be reassessed. So I'd have a partial reassessment for the excess over the fair market value. I could do it 3 times. So if I'm $1 over, it doesn't get blown out. Okay, and then we said that, we had the victims of wildfires who lost their homes in wildfires. They'd be able to buy homes and they'd be able to keep their tax base. And then we also had people who were severely disabled. They'd be able to move and keep their tax base. And any other disaster that was declared legislatively or by the governor would allow people to move and keep their tax base. This was very good. California, as we know, is a relatively high, if not one of the highest tax states in the country. And this gave us a little bit of mobility because we always had a kind of since Proposition 13 and Howard Jarvis, a unique property system as compared to other states. But we got that in Prop 19, and that was the area that was featured. This is wonderful. Who would not want that? But there was a dark side associated with that. California also had a very unique structure for parent-child transitions of real property from one generation to the next. Let's explore what that once was. Once upon a time, on our primary residences, we were able to leave those residences as legacy residences to our children, and if our children were not living, to our grandchildren, and keep the property tax base irrespective of the value of the home. It was unlimited. So if I had a $2.5 million home with a $400,000 tax base, I'd be able to leave that to my children. They'd get the $2 million home. They would have a $400,000 tax base. The property taxes would not go up unless they sold the property. So if they used the property, to rent it out, if the parents left to the children the legacy of the home rather than the legacy of stocks, bonds, and cash, they would be able to enjoy that. Well, that has changed. So now, under new Proposition 19, which goes into effect on February 16th, 2021. So we have a couple of silos to talk about today when we talk about the interrelationship between, we have a silo that goes from today, December, I think it's 18th, to December 31st. Then we have another silo that we look at from January 1st to February 16th. And then the new age 55 move around the state rules come into effect on April 1st. So now under new Proposition 19, after February 16th, 2021, when we have disposition of our primary residence by sale, by purchase, by gift, by inheritance, we no longer have that unlimited property tax assessment lock-in. What we have is something a little different now. The other has been repealed. So what we have now is we have the ability to leave our homes to the next generation, and we can give as long as we have a child, the way that the Proposition 19 is written, a child continuing to live in the property. And we don't know what that means. One child, what if I have 5 children? Do 5 children have to live together? One child, and the child has 1 year to make that decision to live in the house. If they live in the house, they will get a $1 million property tax exemption from reappraisal. So for example, if I have a property that's worth $1 million with a $400,000 tax base, and I leave it to my child or children, which we don't understand how that works just yet, and my child or children will be able to have that property as long as they live there, because it's not more than $1 million over fair market value without any reassessment. If that property is worth $2 million and I have a $400,000 current tax base at $1,400,000, I'll be reassessed for $600,000. So we have, it's just the dynamic has changed. The $1,000,000 is worth about $10,000. All right. After that, the house will be reassessed. Before, we've had houses with $5 million, $10 million, $12 million, which were not reassessed, that now are going to be reassessed upon the passing of generation 1 to generation 2. So please understand that a house that was transferred to a child or a irrevocable trust for children before February 16th, 2021 will still be able to keep the 100% of their current assessed tax base in place. Now, second, and more insidious, is we had a second part of the parent-child exclusion that a lot of people did not understand. The second part of the exclusion is that in addition to the unlimited amount of our house that we were going to be able to leave to the next generation, each of us, or a husband and a wife, had $1 million each of assessed value that we could leave to the next generation without having our property reassessed. Now, this is very interesting. Most people thought that that was $1 million of fair market value. So, example, a client of ours had a property in San Francisco, $290,000. They bought it a long time ago. $290,000 was the assessed tax base. The fair market value of the property in San Francisco is $5.7 million. So what happens is under Proposition 13, as it used to be, we would have been able to, under the $1 million, move $290,000 worth of real property. Matter of fact, under the $2 million, if there's two people, or the $1 million if there was one, sometimes we can move $5, $6, $7 million worth of property to the next generation without it being reassessed. Well, Proposition 19 changed that and changed that significantly. So effective February 16th, 2021, that $1 million of property tax exclusion is eliminated. It's gone. And so therefore, any movement from parent to child of real property other than primary residence, which is also being reassessed for values greater than $1 million, will also be reassessed. So if we take a look back at my client in San Francisco that had $290,000 and a $5.7 million, he asked me, says, well, if my son inherits that property after February 16th, 2021, what happens? Well, if after that point, his property taxes would go from $2,900 to $3,000 a year to $57,000 a year. And what happens if the property is in a rent controlled zone? Besides, many people were unable to maintain the properties, the rental properties that they had next generation because of the giant increases in property taxes. And, as landlords, many of us would try to pass those property tax increases through to our tenants. So maybe our tenants wouldn't be able to afford to live there. It is very, very, very difficult. Now, pragmatically, let's try to, and that goes away on February 16th. So one of the things we still have opportunity to move from parent to children, and or if the parents are predeceased, to grandchildren before February 16th, and maintain for life that low tax basis that we currently have. But from a pragmatic point of view, there are some things that we need to understand. I call it a subjective point of view. So we have to be careful not to let the tail wag the dog. So for most people, unless it's a lifetime transfer of property from parents to children, for most people, this increase is not going to impact them during their lifetime. And when we talk about the estate tax modifications and changes, they're not going to impact them during their lifetime because those are taxes on death. So one has to really look inside and say, okay, do we let the tail wag the dog or not? We have to understand that pragmatically, another thing that I'm of the opinion of is I'm not so sure that, one, Proposition 19 is even constitutional, and I'll explain why in a moment. And I'm also understanding that Maybe in a year or 2 or 3, there'll be Proposition 27, which repeals the negative aspect of Proposition 19, because I don't believe the voters truly understood the ramifications of what we voted for and narrowly won and was certified on December 11th of this month. So when we're doing planning or analyzing, we need to keep that in mind as well. Why do I think that we may have a constitutional challenge to Proposition 19? Well, based upon the information, my knowledge, when propositions are brought out to for the populace to vote upon, they're supposed to be one issue and one issue only per proposition. Well, in Proposition 19, not only did we get the change, we got the change for wildfires, we got the change for disasters, we got the change in the parent-child on primary residences, we got the change for parent-child on the $1 million of assessment. We had about 5 propositions that were absolutely changed as a result of this, and 2 major issues, the parent-child exclusion and the age 55 moving around. So whether or not the California Supreme Court is going to take a look at that, they in general tend to shy away from that technicality, but I'm sure we're going to see some challenges that may come along on Proposition 19. Now, solutions. But before we get to solutions, that's Proposition 19. We lose the $1 million of assessed value, worth a lot of money, and we lose the unlimited parent-child exemption on a primary residence on February 16th, 2021. So we have some time, not much, but we have from January to February 16th to do one thing. And the one thing that I think is really important, whether we make a change or we do not, is to take some time to comprehend the problems, analyze a family's current situation, and then decide what to do. If we don't do that analysis, I think we are missing the boat and perhaps missing opportunities. Before I get to the, I guess we should get a little bit, before I get to the problem of a qualified personal residence trust or lifetime transfers to children. We'll do that first. So there is a type of trust that was put together to help keep a home in the family and not lose it as a result of increasing federal transfer taxes. It was known as a qualified personal residence trust. And in a qualified personal residence trust, parents would reserve the right to, they would give the property to a trust, reserve to live the right to live in the property for the next 15 or 20 years rent-free. And then if they outlived the term of the trust, the property would transition to an irrevocable trust or to their children, income tax and estate tax free. A very good potential solution to ever increasing federal transfer taxes. Problem is now, and these are irrevocable trusts. So it says, if you are alive on the 15th year, this shall happen. Well, guess what? Now under Proposition 19, technically what happens when we get that transition, because the parents are going to continue to live in the property, perhaps lease it from the irrevocable trust or from the children, that was baked into that deal. We'll continue to live there, but we were able to get it to our kids at the lower estate tax basis. They may wind up with the property taxes that have quintupled, which would make that proposition almost impossible. Yet they did it 5 years ago, 10 years ago under law that was in effect at that particular time. So I think that we need to take a look at all of those types of trusts because they could cause a disaster. And then the next question is whether Proposition 19, as it impacts those trusts, is it constitutional as well? Because if we can't change the trust and if it's irrevocable, and as a result of Proposition 19, the deal has completely changed, is it right to those of us that have made those decisions years past? We don't have answers to those questions, but we will, and we will sooner rather than later. So let's take a little chat for a second about what's happened politically. And this is not meant to be a political discussion. It's meant to say how the perfect storm comes to play in relation to Proposition 19 and estate tax proposals. In regime change, from going from red to blue, one of the main things that seems to be a theme is a modification to the current estate tax, or we call it the transfer tax system. So in the United States of America, we have a system that taxes the transfer of assets from one generation to the next. It's known as the estate tax. Under the previous administration, under the previous tax act, for husband, wife, or an individual, it was $11.5 million worth of value was able to be transferred. So for a family, inherently, $23 million worth of value would be able to be transferred to the next generation and or gifted to the next generation without the imposition of transfer taxes. This $23 million exemption, because we didn't have 60 senators to make it permanent, expires on December 31st, 2025. So on December 31st, 2025, the 23 million or the 11.5 million returns to the norm of 2017 of $5 million. So the 11.5 million returns to a $5 million exemption automatically on December 31st, 2025. So on January 1st, 2026, we've now lost $6.5 million for getting an inflation adjustment. And the rate of transfer tax is 40%. So that's about a $2.4 million per person, husband and wife, be $4.8 million reduction or increase in estate taxes, moving assets from one generation to the next. That's significant. Now, the current regime, or the proposals that have been put forth by the Biden administration, are different. And so, again, without being political, there's a significant impact on the Senate races that take place in Georgia on January 5th. If it's more likely, if the Senate turns blue, then it's more likely than not that these more aggressive tax policies will be adopted. I think given the fact of all the COVID expenditures and the bailout packages that we have, I think no matter what, whether it be red or blue, we're going to see some increase in taxation, but much more aggressive if it's blue. If it's blue, here's what they talked about. So what they're saying is they'd like to see the estate tax return to what they call its historic norms. What was its historic norms? Well, it's $3.5 million per person rather than $11.5 million per person, and a rate of transfer tax from 45 to 50% for the amount above that. So if one had a net worth of $13 million, for example, and let's just for round numbers say we had $3 million exemption, there would be a $10 million transfer to the next generation, and potentially, believe it or not, a $5 million confiscatory transfer tax that comes to play. There's also another problem that when they talk about things in the estate tax returning to their historical norms, as they like to put it, is that for many, many years, up until recently, there was a differentiation between the federal estate tax exemption amount and the gift tax, which is that which we use lifetime to make transfers from one generation to the next. The gift taxes were always lower. Part of the administration or new administration's proposal is to bifurcate the estate tax, having a $3.5 million exemption at death, but no more than $1 million exemption during lifetime. This presents a problem for us. And let me try to explain what that problem is, and then maybe we can get to some questions and answers along the way. So the problem is that if we make a transfer, so now we're examining and analyzing together Proposition 19. We may have, let's use my example of my client that has the $5.7 million fair market value 5-unit apartment building in San Francisco with a $290,000 tax base. If my client, and let's say that is pretty much his entire net worth. If my client this year, 2020, while we have an $11.5 million exemption amount, transfers that property to an irrevocable trust for the benefit of his child, his son, then he would be able to keep the $290,000 tax base for his son for as long as his son held on to the property. And the gift tax amount, or the exemption amount that he has available, is $11.5 million. He's got $5.7 million that he's transferring. We have no problem under the current federal estate tax or gift tax regime. Fast forward just a few days, because we're just about out of runway for this year. So when we cross the threshold from December 31st to January 1st, we hit the intersection of politics and uncertainty. Now let's do the same exact transfer after January 1st, 2021. So my client decides to give his client or to an irrevocable trust, to son, or to an irrevocable trust for the benefit of son. And we'll talk about irrevocable trusts for a moment and some of the issues that are involved there. Then, under the law as it exists on January 1 or January 2, it should be the same. The February 16th Proposition 19 has not kicked in yet, and we've already have assurances in the legislation that any transfer up to February 15th is not going to be looked back. And now we turn around and we still have the $11.5 million of exemption amount. So we transferred 5.7 under the $11.5 million. We've accomplished in January the same thing that we could have accomplished in December. The $290,000 tax base moved forward. And hopefully, son will now put that into an appropriate and proper limited liability company for many, many reasons. And we also were able to use the gift tax exemption that we had. The problem, and it's an insidious problem. Hopefully, we don't see it. So, assuming we have a blue Senate, and ensuing somewhere in March or April after all the horse trading takes place, we passed, or the Congress passes and the president signs, the new tax package, the new recovery package of 2021. And in that new recovery package of 2021, the estate tax and gift tax returns to its quote unquote historic norms. And the thing that we fear most, which to me as a planner is very, very difficult to understand, this legislation is now retroactive to January 1st, 2021. You say, oh my God, how can that happen? At the time that we effected the planning and the transfers in January 2021, we had $11.5 million exemption. You guys and gals changed it in July of 2021 and made it retroactive to July. Now, what would that have done to us? Well, if I had a $5.7 million transfer, and I had a $1 million gift tax exemption, I have $4.7 million that is over the gift tax exemption. And guess what? The federal government can come in at that point, if the gift tax rate is 50%, and say, you now owe us $2.3 million for the privilege of having transferred that property to your son. What a chilling effect that has. And, you know, we've always said, you know, as attorneys, how can that be? But there is historical precedent for retroactive imposition of laws. Now, some people are still going to take that risk on the hopes that, one, we wait to see the outcome of the Senate races, less likely that we'll have retroactive January 1st at that point. And also to see whether or not, or take the chance that it will not be retroactive, and then it would maybe even from the date of adoption or the date of the vote, but not retroactive to January 1st. So when we cross the line from December 31st to January 1st, we enter the second silo. The second silo still gives us an opportunity to move property under the $1 million of assessed value, primary residences with an unlimited value. But now we have to also take into consideration the possibility of a retroactive, we'll call it Biden estate tax or gift tax imposition. So therefore, when we enter that uncertainty, the net result could be worse than we had before, and we won't be able to deal with that. So we have to kind of think of what are the things that we can do. So there's the other thing that we have to take into consideration is something called stepped up in basis. So under current law, when somebody inherits assets, as a result of an inheritance, they get a step up in basis. For those of you that don't know what that means, inherently it just means that if my property was worth $5 million when I died, my basis, I bought it for $1 million. When I die, my children would inherit that at $5 million basis. So if my children sold that the next day, there would be no capital gains tax. So it'd be 5 million, sold it for 5 million, no gains tax. When we make a gift to accommodate Proposition 19, when we make a gift, our children get our tax basis in the property. So it would be $1 million. So when my child subsequently sells that property, the capital gains tax would be based upon the delta between the $1 million, my basis, and the sales price that they had. Also could be quite significant. We are currently working on and believe we have found a solution to be able to create trusts before February 16th that should be able to allow us to transition property from parent to child under both exclusions into a trust that qualifies under Proposition 13, and by changing certain provisions in the trust, causing those assets to be included in the estate so we still get a step up in basis. So that would be the best of all worlds. We have to analyze every situation in the very, very short period that we have to see whether or not that's applicable. Now, last but not least, after February 16th, on transitions of property, Prop 19, although impacted parent-child on both levels, Prop 19 did not impact commercial property, and Prop 19 did not impact anything as when we move an LLC or the use of business entities, LLCs and limited partnerships from one generation to the next. So through a significant amount of planning, it may be possible through the use of entities to bring property from generation 1 to generation 2. It's highly technical, it doesn't fall into every person's category, but there are strategies that are going to be developed to help a family legacy live on in the state of California. We've already have enough tax in this state. As I said, the power to tax is the power to destroy, because if our children can't afford to hold on to the house or the property that they've inherited because of the tremendous increase in property taxes, those properties will have to be sold. And with that, that's about the information that I want to give. I'll have a few minutes to grab a couple of questions if we have any, Paul.
Yeah, we do.
Please, let's go ahead. Let's go do them.
Okay, I'm going to jump right in. If an existing established credit shelter trust is in place with kids as beneficiaries, grantor deceased and trust funded, but spouse is alive, does the real estate in the credit shelter trust get reassessed per Prop 19 on spouse death?
And to the best, if it's in there now, that transition has taken place. So it's under Prop 19, the actual transition of the property occurs on date of death. The issue that comes about is whether or not when the spouse dies and now the property moves to the children through the use of the bypass trust. To the best of my knowledge, I would imagine under Prop 19, if it happened after February 16th, that would be reassessed.
Okay. Is the property tax reassessment exclusion applicable for people 55 or older that bought a new house within the last 2 years or 2 years ago? Is it retroactive?
Not retroactive. It becomes effective April 1st. One of the questions that we have is what happens if somebody's beginning to make that transition, starting it before April 1st, ending it after April 1st? We don't know. We just know that if we start after April 1st, the 55-year-old throughout the state exemption applies. Prior to April 1st, it's the old 55 exemption intra-county.
Okay. My spouse and I live in California. Can we put our rental property currently held in a living trust into an LLC without triggering a reassessment? The LLC will only include my spouse and me, no change to ownership and property.
Yes, you can. You could put it in without a reassessment. It's an interspousal transfer. As long as it's proportionate, to the best of our knowledge, there will not be a reassessment on that.
Okay. After Prop 19 is enacted, if a parent passes and the primary residence is passed along to 3 children, and one of the 3 children makes it their primary residence, will there be a reassessment? I think you kind of addressed this.
Yeah, let me address that one again. It's because we really don't. That's a great question. We don't know the answer. It's kind of ridiculous if the law basically says that all 3 children and have to live in the house in order to keep that $1 million worth of exemption. So my bet, and we don't have an answer from this yet. We don't have regulations. My best guess is, I don't know whether it's going to be proportionate. You get 1/3 of the exemption or 2/3 of the exemption. We just don't know the answer. I would imagine, I would hope that if one child is living there, and also, by the way, that exemption applies to a family farm, that they get the $1 million and they have a year to get there. Now, the other question that comes behind that is what happens if they move out 2 or 3 or 4 years later? Do we lose the $10,000 of exemption amount when a child moves out and turns it to a rental property, or do we keep that $10,000? We don't know the answers to those questions as of yet, but we will know those very shortly. How about one or two more questions, Paul?
Okay, a couple more. Will the Biden tax plan remove stepped up basis?
Well, it's a conversation. So let's understand a little bit. I didn't go through all the tax rules that was talked about on the campaign trails. One of them was for people earning greater than $400,000, the elimination of capital gains tax. One of them is the elimination of stepped up basis. Another one is elimination of grantor trust. Another one is the raising of the basic income tax. Another one is to turn around and lower the estate tax exemptions to $3.5 million. Another one's to bifurcate it to $1 million. That is a wish list that was put about on the campaign trail. Whether or not that gets adopted or not is highly dependent upon the control of the Senate, and also, even if we didn't have control of the Senate, on what a realistic picture will look like. I don't know whether all those things will be adopted or not, but in today's politics, I can't opine on that.
Right. Okay. Can we take 2 more, Harry?
2 more.
Okay. I understand the loss. Actually, yeah, I'm getting a lot of questions there. I understand the loss of step-up basis may also be part of the Biden tax plan. How likely is this an impact on present gift decision versus waiting to inherit?
Well, I think, remember, if we wait to inherit, if we're inheriting after February 16th, if I understand the question correctly, then we're going to be reassessed on the properties. Pretty much so, in a general sense. And also the step up in basis, which occurs on death, would be the law that is in effect at the time of the inheritance. So if we do it now in the form of a gift, we're not getting a step up in basis on death, absent those potential changes that we can make in trust to try to get the best of both worlds. I think that if I was a gambling person, I would hope that we would turn around and continue to get a step up in basis. So I wouldn't overreact to that at this time. Again, pragmatic. Does Prop 19 survive? Does it get changed? And what gets elected? What gets impacted? I just think that there's a lot of uncertainty. So the major thing that's certain is each of these situations need to be analyzed. Last question, Paul.
Okay. Well, I wanted to make sure and put this up on the screen here. Can you see the text?
Yes, I can.
Okay, so for those who came on late because the numbers kept climbing, I wanted to make sure I announced this at the end. We can't get to all the questions. I've got 1 million questions popping up here and some sent to me beforehand. We want to answer every question, and the way to do it is to sign up for your free strategy session with Harry and the team. If you text guard assets to 474747 there on the screen, it'll get you to our calendar. You can book that and get one-on-one to answer your questions. And the last one I'm going to have here, they just keep rolling in here. Last one. If parents put properties in an LLC and there's no property tax reassessment, will children inherit LLC and avoid reassessment as well?
Okay, that is an absolutely great question, and it has a bifurcated answer. Under current law, if the parents have put the property into an LLC, and then on death, the LLC is inherited by the children, under a quirk of current law, under Proposition 13, that is not a transfer from parent to child. That is a transfer from LLC to child, and they would not get the $1 million exclusion from property tax. So in order to get it, parents have to go directly to child and not through an LLC. So parent to child directly qualifies for the exemption. Then child can put the property into an LLC and we are fine. Post February 16th, 2021, it doesn't matter anymore because the parent, that $1 million exclusion for each parent is gone. So at that point, it's better in an LLC, one for asset protection purposes, for estate tax purposes, and for transition to the next generation, because Prop 19 did not affect LLC transfers from one to another. There are very technical rules for that beyond the course of the scope of what we have to do today. But so you got two different points in time, pre and post February 16th on that. And with that, I'd like to thank everybody who joined me today. There is a cone of uncertainty, this is for sure. We need to work through that together. We need to analyze that together and make the best choices. But most importantly, never let the tail wag the dog. In chasing the tax benefits, let's not mess up the things that are really important in a family. And with that, I'm going to say thank you very, very much. And Paul and Alexandra, thank you for having me with you today.
Yeah, thanks, Harry, Alexandra. Great information. Thank you, everybody. We've recorded this. We'll get it out to everybody who registered. Alexandra, thanks again.
Absolutely. Have a good day.
Okay.
Bye.